Today is part 4 of our 4-part construction series. We started this series several years ago in response to companies that are in the construction industry. Again, business owners, you are expert at the delivery of your product and or service, but there are other issues that either trip you up and become barriers to your success, or things that you did not even consider as you were negotiating with an owner or a prime contractor or a prime consultant. And so we put together this series, and for the last several years, from the time we started the series until today, we have been fortunate to bring experts, professionals in the construction industry to take each part of this series and bring their expertise. And so we started with the expectations, series number 1 of the series, part 1, expectations of the prime consultant or prime contractor or the owner. What are the expectations that they have of you in the performance of the job? Part 2, we brought in the City of Philadelphia Office of Labor to talk about certified payrolls. So if you are working for the city or some other entity that has federal funds, you need to know what is required of you in preparing and submitting certified payrolls. Part 3, we talked about bonding and what are the requirements for you in getting a surety bond. So we have partnered for several years with Ellen Nayland of Surety Bond Associates. And then on today, we wrap up the 4-part series with construction law, liens, and dispute resolution. And we are fortunate again today to have with us Jennifer Horn from the law firm Horn Williamson. And I will tell you that Jennifer started with us when she was a partner in a previous firm and decided to spin off into her own practice. And for all of this time, she started with us when she was a partner in the previous firm, and we have had the good pleasure of watching Jennifer grow her own practice. She'll tell you, I think she now has about 10 or 12 attorneys who are working for her. Her partner, Carter Williamson. This is a construction and commercial litigation firm. And so what they do is construction. They serve the Mid-Atlantic region. Jennifer has comprehensive construction experience in client representation, project counseling, negotiation, and litigation. She's built her practice representing homeowners, construction managers, contractors, subcontractors, suppliers, sureties, in matters arising from private, state, and federal construction projects. The firm's practice is on all aspects of construction claims, commercial disputes, representing, again, all of those types of construction entities that I mentioned. She assists clients with an array of construction matters, including construction review, negotiations, scopes of work, change orders, delays, all of those issues that come up in the course of construction. I will say also, for those of you on this call who are not in construction, contracts are an issue, conflict resolution, litigation, expectations when you are working with clients. These are all issues that still impact you, even if you are not in the construction industry. So we have encouraged callers and participants on this webinar, whether you are in the construction industry or not. The information that you're going to get today from Jennifer is going to be relevant to you, and you will find it will be extremely helpful as you are navigating your way in working with consultants, working with clients, working with contracts. And so then, without any further delay, it is 9:09. We are scheduled to go until 10:30. Again, we encourage you to use the chat function, check it for all of the links that we will include, use the raise hand function, and we will unmute you where you can ask your question directly to Jennifer. And if you want to remain anonymous, please use the Q&A function. And so now, Jennifer, my friend, Jennifer Horn, who is coming to us live from Vermont. The technical difficulties we were having, if you remember the extreme high winds that we had last night, Jennifer is experiencing some of that right now in New England. So we are going to try to stay live with this webinar. So now I'm going to turn it over to Jennifer. Jennifer Horn, take it away.
Thank you very much, Marla. And I guess technically I wanted to confirm that everyone can hear me. Can you hear me?
Loud and clear.
Awesome. Well, thank you, everyone. As Marla mentioned, we're currently experiencing some high winds. Again, I apologize for any technical difficulties that we're having, but we're here today to talk about the toolkit for contractors. And really, it's a toolkit for business people. In any business, it is essential that that everyone assemble teams of people that can assist in critical areas. These include the insurance piece, which I know we've had a seminar about. It includes the legal piece, which we're here to talk about today, but equally as important, the accounting piece as well. So it's important to know who these members of your team are, and then to utilize them going forward. If we could turn to the next slide regarding the outline of what we're going to discuss today, we're going to talk in the world of construction contracts, the importance of the pre-bid and pre-qualification, moving into negotiating the contract, and then essential documents that are required to make sure your project goes smoothly, the preliminary documents, and then the documents you'll generate throughout the job, and then also claims, avoidance, as well as the project closeout. Going to the next slide, as we discuss the pre-bid and pre-qualification process, estimating is one of the most important aspects of construction law. Managing your risk with estimating costs is essential. We want to understand, as an estimator, what subcontractor material buyouts are going to occur. So getting accurate pricing of materials, engaging qualified subcontractors, screening those subcontractors is critically important. We want to also be mindful of ever fluctuating labor issues, such as wage rate increases and so forth. As many of you know, in construction in Philadelphia years ago, we had impacts with steel prices that still occur, drywall costs, and other things that fluctuate. So knowing the market before the estimate is done is critically important. Many times a project is won or lost at the estimation phase. And construction firms all over the city, when you ask them what is perhaps the most important part of the job, they will all tell you estimating your costs. When times were really tough in the Great Recession, many times people would estimate jobs without building in any profit, hoping to make up the issue with a signed change order later on. If we can move to the next slide. Everybody wants to make a profit. You're in business so that you can grow and cover your costs, but you want to get the job as well. So there's an innate tension between the pressure of estimating this project in a way that gets it completely performed for the estimated costs, and the opposite side, which is the tension of competitive bids and getting the job in real time. Next slide. Many contractors have been there when they're awarded the contract with a bid that's too low. And in that case, that hurts everyone involved. The owner expects and deserves quality for a price, and that contractor may not survive the de-scope period. A poorly estimated job impacts your relationship with subcontractors, and it could mean that a contractor is locked long-term into a losing proposition. This is why this pre-bid, pre-qualification aspect is so critical. If we move to the next phase, we talk about pre-qualification. Contractors of any shape or size must have a subcontractor pre-qualification process where you're collecting data from subcontractors, creating a database, and prompting subcontractors to update their information periodically. Subcontractors can complete forms containing that necessary information. Next slide. The next slide. When we talk about the information needed to pre-qualify a subcontractor, we look at the name and the address. We look at MBE, WBE certifications as well as licensing. If we can move to the next slide. A note about licensing, we want to make sure we're clear that licensing is state specific. So a job in New Jersey or a contractor licensed across the bridge needs to understand what is required with regard to Pennsylvania as well. The pre-qualification experience of a subcontractor is worth noting. What types of work has that sub performed in the past? Have they been terminated or failed to complete a project in the past 5 years? Are there lawsuits pending against them? These are all things that one must look at in order to complete due diligence. And we look for details that are occurring at least for the past 5 years. And we wonder as to whether or not any lawsuits that they have filed or arbitrations have occurred in the last 5 years. We look to principals being convicted of crimes, especially those related to fraud as well. And we then ask whether a contractor or owner has terminated any subcontractor for cause on projects. When we negotiate these and we're dealing with terminations, often in that negotiation, the termination for cause is a very critical piece of that puzzle. If we move to the next slide, you want to know what is the size of the subcontract, the size of the project that they've done. What work does the subcontractor typically subcontract out? And then with regard to the surety information that you've dealt with Ellen Nayland, what bonding capacity does this subcontractor say? It's important to ask for a letter from the surety confirming that it will be bonded. When we go to subcontractor pre-qualification, if we move to the next slide, we look at the OSHA 300 information, safety information, and move on to workers' compensation experience on the next slide with your EMR rating for the past 3 years. Paying mindful attention to the safety training programs and their issues regarding drug-free safety in the workplace and drug testing protocols, as well as the information that's needed. We can move on to the next slide as well. When we talk about the pre-qualification again, we can flip to the next one. In order to understand pre-qualification of a subcontractor, we absolutely need to look at the financial information, what an accountant should review, and whether or not there's a non-disclosure agreement required if applicable. Next slide, please. As a subcontractor, you should sign the application and certify that all information you know listed on that application is true and correct to the best of your knowledge. And the contractor, again, is relying upon the accuracy in awarding work to the subcontractor. As a subcontractor, I want to get this analysis done in advance and get it done ahead of time so that my ducks are in a row when projects are available to be bidded. If we move on, when we talk about negotiating the contract, there are certain things that we need to think about in that contract. And the contract can often be quite voluminous, and we want to point your attention as a construction lawyer. We always point our attention to they're really critical pieces of this puzzle. But before you even negotiate your contract, we want to understand what our lien rights, our mechanics lien rights are in the state of Pennsylvania, the Commonwealth of Pennsylvania. And that has to do with the deadlines under the lien statute, notice requirements, and what we need to do to actually foreclose. It is different. The lien right statute is different than a complaint for breach of contract for many reasons. But let's move to the next one. In addition to knowing your lien rights, we want to know our bond rights. What is a surety bond? Do we have a bond claim? We want to read the bond and, most importantly, have a copy of it before we sign that contract or very early on in the job. The deadlines with regard to bond claims are really critical, and the notice provisions are something we need to look at very carefully. Typically, there is 1 year to file suit on the payment bond from the date of the last work performed on the project. Next slide.
Hi, Jennifer.
Yes.
Hi, yes, we actually have a question in our Q&A box real quick. It's from
Wonderful.
Lawrence.
What is the question?
The question is, what search would show lawsuits and judgments?
What searches should you, I'm sorry, can you repeat the question?
Yes, what search would show lawsuits and judgments?
Great. So when clients call us for this search, we would do a search on the Lexis database. And we would do a search for any lawsuits or any other issues that have come up on that Lexis suit. There are other services that you can engage to do searches to see if the person has been sued in the past or if there's criminal records. And you can call any process server in the city to do that, or your construction lawyer can point you to a service. I hope that answered the question.
Yes. Thank you, Jennifer.
Certainly. Moving on, we want to understand your rights under CASPA and the Public Prompt Payment Act as well. CASPA is the Contractor Subcontractor Payment Act. It's not applicable to any public projects, and the Public Prompt Payment Act, that applies to public projects as well. These are other weapons in your arsenal. And again, we never want to use the weapons, right? We never want to have to exercise our rights. But if you know, information is power, and if you know what to think about prior to entering in to this contract, you're going to be much better suited to preserve the business relationship as you work through these problems on the job site. Again, when I'm negotiating a contract, the very first thing I think about is what law applies. Just because I'm in Pennsylvania doesn't mean the contract is applying Pennsylvania law. A lot of people don't know that. We've had clients that have signed, for instance, contracts with large companies, and they're putting in a branch facility. But instead of Pennsylvania law applying, it's the law of where that home company is. Walmart, for instance, is notorious for making people negotiate and settle disputes in their Bentonville facility, not in Pennsylvania. And they will fight and prevent any Pennsylvania law from being applied to those issues. You're crossing borders at your own risk. We often, in the Great Recession, saw contractors crossing the border into New Jersey or down the street into Delaware or up into New York, assuming that the rules of the game were the same as what they were familiar with in Pennsylvania. And they found out the hard way that sometimes there are critical differences when you cross borders. If we go to the next phase, again, your legal team is going to help you through this process. If you're handed a contract and you simply don't have time to review it, it is not a problem to call up a construction lawyer and have them say, you know, Jennifer, I've got this contract, spend no more than 45 minutes giving it a spot review and telling me what I need to know. And when I'm looking at that contract, my eye is going to go immediately to something called the dispute resolution provision. This is whether mediation, arbitration, or litigation applies to your project, and we can talk about this. And that's one important issue. If we flip to the next slide, we're also going to look at what project documentation you need. As I'm entering the contract process, I want to preserve the business relationship with the people I'm contracting with. But at the same time, I want to make sure my ducks are in a row and I've got essential preliminary documents. So what can I do? I can say to the person who I'm in the contract with, listen, I don't think I'm going to need it, but my accountants and lawyer team, they require a copy of the bond before I sign the contract. Can you get that to me? Another aspect is, listen, again, I don't think it's going to be an issue, but can you give me the general conditions on this project? I'm noticing here there's an integration clause in this contract that shows what's happening up the chain between the owner and the general contractor. Is it possible to have a copy of that contract so I can really see what's integrated? Again, it's not me, it's my lawyer. You want to blame your accounting, insurance, and legal team for the essential documents that you want to get up front in the honeymoon phase before any issues arise. If you've got these documents in advance, it's much easier for you to navigate the tricky process going forward if, in the unlikely event, there's a problem going forward. Next slide.
Jennifer, if I can just jump in for a minute, one of the things that I find myself saying to our clients often is, as they are looking at and contemplating signing subcontract agreements, they are looking at a document that has been prepared not by the person who is giving it to them, but it's been prepared by the lawyer for the company that is protecting the company. And so for our client who is trying to or expecting to review that subcontract agreement, they should likewise have their lawyer looking at that contract to protect their interests. Too often, the contractor is looking at a document that's a legal document being presented by someone they've worked with in the past, who might be a project manager, who might be an estimator, but that's not who prepared the document. It's the lawyer. And so lawyer to lawyer, we encourage our clients to make sure they've got a construction lawyer who has looked at it to make sure that the wording, the terms, the conditions work for them also. Just wanted to add that.
That is an excellent point, Marla. And I would add, there are many people who receive a contract and have no changes to it. They don't read it, they just sign it. And that is done with their peril. There are still many people that ask for changes. So sometimes subcontractor clients think, wow, the contract is what it is, and I have no power because I really need this job and I really want this job. And so out of fear, or because they simply don't have time, or they haven't hired a construction lawyer, they don't ask for simple changes that can be dramatically beneficial to them later on. Many times, if a general contractor and owner sees someone that has no changes, they're going to be disappointed. They're going to think, wow, is this person not even savvy with business that they don't think to ask for changes when the other side is expecting a negotiation and that doesn't happen. So you absolutely want to have this document and your contracts reviewed by qualified professionals, even if for only a short time. That way you can protect yourself going forward, with terms that are there. If you don't ask, you don't get. And that's a critical comment. For project documentation, again, we want to have documents ahead of time. If we can switch to the next slide. Now, one thing that's really important that good subcontractors and general contractors all do is that they are attentive to project communications, and this leads to claims avoidance. If you are vigilant about how you're communicating the good, the bad, and the ugly within your company, outside your company, and to the owner contractor, you will be in a much better situation. If it is not in writing, it didn't happen. And writing doesn't have to be written. It could be photographic evidence. If you want to provide notice or a real-time documentation of what's happening, having your people photograph the job site, even through the use of drones, which is very common on city projects and other things, that is very critical. The key to avoiding claims is knowing the provisions in your contract, sticking to them, and giving notice of any claims that you have. There are timing and scheduling parameters that relate to notice. And remember, if something happens on the job, you want to be able to show your people, your experts, but also opposing counsel before it's cleaned up or fixed. Otherwise, information can be spoiled. If we go to the next slide. When you're at the project closeout phase, that documentation will serve you well, because many times people forget what happened at day 1, day 2, day 3 of the project. And if you don't have documentation that says, gosh, I couldn't get in there, the mason wasn't finished, or there was a weather delay, or the electrician was holding me up. If there are no photographs, emails, or other evidence about that, and you now want compensation for delay, that's going to be much harder to do if you have not documented. And then when we get to the project closeout time, your arguments are not as persuasive if the documentation is not there. Many times we'll negotiate what the substantial completion date is. We'll negotiate punch list items as opposed to base contract work, as well as warranty work. Next slide. We're going to be dealing with the current project as a business and learning opportunity for your next opportunity. As we all know, Philly is a small, small town, and relationships matter. We'll say it again, relationships matter. If I'm a stressed out owner or a troubled GC, and I've got a limited pot of money to pay out, who am I going to pay? Am I going to pay the subs that have documented their issues, have preserved their claims, and know their rights? Or am I going to document, or am I going to pay the subs that have been ignorant to those issues? You want to be a subcontractor who has preserved your rights so that you're further in front of the line for payment. Those that sit on their rights, of course, will not have the better outcome in that relationship. We also want to make sure that we're not burning bridges where we don't have to. And there's a way to be smart about asserting your right to payment and still preserving that business relationship. Because again, what you're doing on the job today, whether you like it or not, is marketing for your next project. All right, and we're looking at the contractor toolkit, the risk avoidance from inception to closeout here that we've talked about. And I guess I want to go back and I want to talk about the dispute resolution issue that we had touched upon. When we talk about the importance of provisions in the contract that we want to make ourselves aware of, we're looking at dispute resolution, and that was further up in the slide. We're looking at litigation, arbitration, and mediation. So when I'm looking at that contract and I'm thinking about what my dispute resolution provision is, mediation is very different from arbitration, very different from litigation. And we'll give you some examples. Mediation is a wonderful way to solve a problem where everybody gets a say in what happens. No one accepts an outcome in mediation on their own. What we do is we'd hire a separate construction attorney or retired judge, and that person shuttles between the people having the dispute and creatively work out a problem. And sometimes settlement is money. Other times settlement is a scope of work. And sometimes a settlement is a combination of money and a scope of work. And it can also be a creative thing, like future work. We've had mediations where a subcontractor has wanted to get paid. The GC may not be flush with cash at the moment, but a partial payment may be made, and the promise of future work and future relationships. And that's been very successful. Mediation can be a condition precedent to arbitration and litigation. So you want to look in your contract to see if mediation is a requirement or a condition precedent. Then we need to know, and it's very, very important, to understand whether dispute resolution provisions are solved through arbitration or litigation. Litigation is in court, and the judge may or may not know construction law. He or she gets paid the same salary, whether they spend 5 hours on your project or 5 minutes. So they are not swayed by money in the same way that an arbitrator who is paid hourly maybe could be, like it or not, in an unconscious bias. If an arbitrator is making $500 or $600 an hour, split between the parties, each party pays $300, are they going to spend a lengthy amount of time on your issue, or are they going to spend a short amount of time on your issue? So it's something to think about, because the costs of arbitration can be very high. On the other hand, you get to select your arbitrator. So you can choose a mason if I've got a masonry issue. I can have an engineer as my arbitrator if I've got a site work problem. I can have a lawyer, a construction lawyer, as my arbitrator if it's an issue. So the dispute resolution and the pros and cons of each are, again, a critically important piece of that puzzle. Now, once I'm resolving my disputes, then I've got to think about the causes of action that I have. And the causes of action are like fingers on a hand. And I want to get to the result as quickly as possible. And I only need to tag that end result with one finger, so to speak. And those are different causes of action. So for instance, when we go to the slide that talks about CASPA, or the Prompt Payment Act, those are statutory causes of action that we have at our disposal. The Contractor Subcontractor Payment Act is a statutory issue in Pennsylvania, and we're very lucky because that statute has teeth. It is a statute that is extremely powerful, and if you're not getting paid, that's something you should know about and use. The Public Prompt Payment Act is also a statute, and that also is a very useful cause of action available on public projects only. The surety aspect, that is a separate cause of action. That is a softball pitch. The reason we spend so much time talking about your bond rights is because it is an easy way to get paid. If things have gone bad and you've not gotten paid, and you've got a payment bond on the job, you simply need to notify these folks timely of your notice of claim and get it done. The time for making a bond claim is very short. It's typically 1 year, but it is a slam dunk, very easy cause of action that's available as well. Another cause of action is your breach of contract. If the contract is violated for any reason, let's say from a scheduling perspective, and many times the contract includes your schedule in that contract. If it's violated, then you have a breach of contract action, and you can sue for payment on that breach of contract. So that's very important as well. And then also the lien claim on that mechanics lien statute is very important. And that's a cause of action that you have against the owner. And we spend a lot of time trying to identify who that owner is. We run a title search to make sure that that owner is truly who is attached to the land. And then what we'll do is we will make sure that we're following that lien statute, not only with the notice provision, but then filing a complaint to enforce that lien right in a separate action. That mechanics lien is a very powerful and potent cause of action against the owner, which is very different than the other causes of action and something that's used sparingly. Because when you exercise that lien right, the owner can no longer transfer the property or sell their property. And that is a very heavy and important aspect as well.
Jennifer, if I can ask, for a lot of subcontractors, the idea of filing a lien, the fear is it may help them today, but it impacts their relationship. And you talk about relationships being so important. If they file the lien today to protect them on the current project, the impact, the longer term impact could be that they don't get the chance to work with that contractor in the future. So how do you address filing a lien and yet trying to maintain the relationship with the contractor moving forward?
Very important. You don't just wake up one day and file a lien. There are many, many steps to get to that end result. So in terms of the relationship, oftentimes simply filing a notice of intent to file the mechanics lien, just the notice of intent, can preserve your right and also signal the relationship. So what you can do is we can say, listen, you can say to the contractor, I do not want to file a lien. It's the last thing I want to do, but I'm filing this notice of intention on the advice of my counsel and my legal team. We don't want to pull the trigger on this thing, and we know you're going to pay us and work this out very quickly. But I'm being told that if I don't preserve the right by filing a notice of intent, my lien right is lost. So often that notice of intention form can serve as a very good resolver of the conflict, because many subcontractors, it doesn't even occur to them to do that. And if they're not up on their rights, they won't know the force and effect of that. But if you have good construction legal counsel and you're not getting paid, we're going to try many different creative avenues to really nudge and alert the owner and the counsel on the other side that, look, we've got a smart contractor here who understands the rules of the game and knows how to play them. And that is respected in business. And we found that you can preserve a relationship simply by filing that notice of intent with an email enclosure that's more soft or collaborative as well. Thank you for the question, Marla. Does anyone else have questions? Yeah, it's definitely a different thing to do this remotely from Zoom. And I got to say, I miss the warm welcome that we always get from Marla and her team with coffee and donuts and shaking hands and all the rest of it. And we're so hopeful that next year we can safely be in person and get back to some semblance of normal. But what is the question?
Yes, we do have a question. If the construction contract does not require permits pulled, can the property owner still hold the contractor liable if certain code violations were discovered after the completion of construction?
That's very interesting. So before you get involved in a job, it must be determined who is pulling the permits. That has to be made clear. And if you're walking onto a job and it's not made clear, and they're adding that to your scope of work, then you're going to want a change order to spell out time and money that's required to get that done. Many times when change orders come about, whether it's an add or a deduct, everybody jumps to the money portion. But equally as important, especially if the permitting phase, is time. So you never want to sign a change order without adding on to that change order the impact it will have on the time it's going to take, either added or deducted from that schedule. So then if it's not clear, it becomes a negotiation. And negotiating after the fact when a contract has already been signed is always harder than at the front end. So if you're being asked to take on additional responsibilities, that needs to be something that you're compensated for and the timing is addressed. If someone's trying to thrust something on you that's not in your scope, that's not in the schedule, then that's something that you need to call your construction lawyer about, and it has to be then negotiated into the field. The building code, and I'm happy this was mentioned, is extremely important. And when violations are discovered of that building code, obviously there are problems with regard to that. And violations can be discovered not only through L&I, but through construction managers that are on site as well. We've noticed in Philadelphia, especially in the residential construction arena, there has been an avalanche of residential construction problems relating to water penetration, water intrusion. In the past, L&I wasn't paying attention to water-related building envelope issues. No one was in the entire state. Why not? It wasn't required. It was unheard of that an inspector would look at these issues. Now, however, after thousands and thousands of complaints and claims, that's becoming much more prominent. But your responsibility to build in accordance with building code is separate and distinct from any kind of inspections or certifications that you get. So if I go to a house and I improperly flash the building envelope such that water penetration is now rotting the oriented strand board, I am still on the hook for that, regardless of whether or not that building passed inspection. And that is law out of the Superior Court of Pennsylvania. And also it would be under the breach of contract, because when I sign my contract, I'm agreeing to perform my work in accordance with the building code, ASTM standards, plans, specifications, manufacturer installation instructions, all of that. That's part of the contract and part of how I must perform my work. So that's always critical. And if you don't know, let's say the spec is murky, the plans aren't detailed enough, then what we need to do is ask that design professional. And this comes into play all the time. There are things called RFIs, requests for information, where you're asking that design professional for more specifications, for a better understanding of what's occurring. And you should not hesitate to do that as well. I'm seeing a question that if a contractor bids a job and is awarded the job and signs the contract. All right, so let's back up. I bid it, I'm bidding that job. So that means I should have had an estimator accurately understand costs of materials, the costs of the work, and the time it would take me to complete that work. So I've now bid that job. I relied on my estimator and I bid it. I've gotten through the pre-construction, pre-qualification process, which is always harrowing. And I've now been awarded the job. Yay for me. Now I've signed that contract. And this happens all the time. I fail to account for a price escalation in materials. Am I entitled to later seek recovery of those costs? Well, I'd have to read the contract because the devil really is in the details. Some contracts have material escalation clauses that account for this. So if my estimator is telling me, gosh, Jennifer, I think the price of ABC is going to be X, but we're not sure. The AIA contracts that we look at all the time have form provisions for cost escalations. So and material escalation as well. So if your contract accounts for that, you may be okay. It may be all right. If your contract doesn't provide for that, though, you could be on the hook for that. So again, pricing information, how I'm getting paid, is a critical piece of the puzzle for this contract. One thing we always say when we're standing there and I'm actually seeing you, because the last thing I want to be is in quarantine with kids, virtual schooling, waiting for my husband to have a second vaccination. I want nothing more than to be back in my Center City office, staring out at City Hall, going to La Colombe, walking over to see Marla and her beautiful offices. But in any event, one thing we always say is that anyone who attends any of these seminars will get a free consultation from Horn Williamson. So you're free now to ask any question you want, and I'll answer it. But if you have an issue, you can always call and do an intake. And you'll call our main number at Horn Williamson, and Kayleen will take your information, and you want to say, I heard Jennifer speak. And what will happen is that Carter and I will do a 20, 25-minute consultation on anything you're thinking about. And it's for free. And we do that as a courtesy to the relationship we built with PIDC, which is an amazing organization. And we also know that a relationship that's a legal relationship, just like accounting and insurance, happens over time. You don't want to call me up for the first time understanding that you've got a massive problem that needs immediate attention. That happens all the time, and we can spring into action. But it's much easier if I've met you before, if we've looked at the contract together, maybe for a half an hour, 45-minute time. And then if things start to get tricky, we have a familiarity with that contract, and it's much easier for us to assist. There are certain things like bid protests that are very time sensitive, that if you feel like you were the low bidder, but someone was awarded it for a reason that wasn't right, those things are time sensitive. So much like you have an accountant and a person to do your bonding, if you develop that relationship at the front end with the construction lawyer, when something occurs, then you can call me up. You want to definitely ask for time with people on these teams and make sure that you've got the right person for the job. All we do is construction. For over 25 years, I have done and represented pretty much everyone at the construction table, from subcontractor to supplier to architect to engineer to owner to surety. Early in my career, we worked for sureties as well. I've represented folks in residential construction as well as commercial construction. We often get the question at these seminars for contractors that are doing residential work. If you are the person giving the contract to a homeowner in a residential arena, you must make sure and be very careful to be following the Homeowner Improvement Act. And one thing we can do is we can look at the contract that you're about to hand out and say, yes, that complies, or no, it doesn't. If you're a general contractor, we can give you a contract that is very pro-GC. If you're an electrician, a follow trade that's very concerned about time and schedule, there are provisions we can add and ask for to help the ability for you to have a good contract as well. So all of these things, like anything, if you're planning right and you've got a team assembled, you're in a much better position. I'm a lawyer. I'm not a dentist. I'm the person you call when you're not getting paid on the project site, not when you need a root canal. It is completely irresponsible for you as a business person to think that you can be a tradesperson and a lawyer and a CPA and a facilities manager and an insurance professional. The reality, of course, is as business owners, we all wear many, many hats. and we are all thrust into areas where initially we're uncomfortable with. When I started my law firm, I gave nary a thought to accounting. At large firms that I'd worked with in the past, the paycheck would show up every 2 weeks, and I didn't give it a thought. I thought accounting was boring and something I didn't need to deal with. Well, you learn very quickly as a business owner that if the money isn't right, that nothing is right. And so you must have people that have, very good experience with those issues. A question is, does our firm have lead paint related experience? Actually, I'm licensed as an attorney in Pennsylvania, New Jersey, DC, and Maryland. And I started my career in the DC, Maryland area. And Baltimore, as many of you know, had an amazing problem because of the location of different paint plants with their inner city with lead paint. So the early part of my career, I spent a lot of time with lead paint related issues. It is much less common in Pennsylvania now and in recent years, but we have handled those issues. Lead in the water is also an issue as well. And we do have attorneys on staff that are very experienced with this as well. The answer to the question, can slides be made available to attendees afterwards? I defer to Marla, but I know in the past that the slides have been made available. And if you want to email me, we're happy to email that to you as well. It's jhorn@hornwilliamson.com. Carter regrets that he couldn't be here today. Carter loves these presentations, and it's much more exciting when you're listening to somebody else talk, not just me. But in any event, I wish all of you good health. We do have time for more questions. If anyone has other questions, please feel free to type them out.
Jennifer, thank you so much. I'm going to guess that we still have some questions that people have not yet asked. One of the things I will say, as we often say, businesses should look for professionals to add on their team that have specialized knowledge in their specific industry. And so for construction, you should be looking for a construction lawyer who will understand how to interpret the language in the contracts. A general practitioner attorney may not understand the nuances associated with construction. And so the idea that you start to plan your annual budget around the costs associated with hiring a construction lawyer or an accountant that specializes in construction is something that businesses should pay special attention to. So your strategy in building your budget should include not only expenses for memberships, not only expenses for marketing, but also expenses in your budget for having an attorney that you can build a relationship with and call when you need their help, because they know you and you're not trying to start a relationship in the middle of a conflict. What else?
That is very true. When you are in the middle of a conflict, it is not the time to start assembling the team. It happens all the time and we can do it, but when you're in the heat of that moment and the business pressures are so intense and so stressful, the last thing you need is your attention diverted in other avenues. So, get your team lined up beforehand so you can call them when you need them. I've got a question here. You discussed certain liens that subs may be able to file. Can a lien be filed on a project by a city or government agency if the sub has not been paid? Well, there is a Prompt Payment Act. You cannot generally lien public projects. The liens really occur with private projects, but there are prompt payment acts that relate to public projects that are other avenues of payment. Any other questions?
We do have
One
a
comment that, oh, go ahead. Sorry, Marla.
We do have a question in the Q&A that says, what does a pay structure look like in retaining a construction lawyer for a year?
Oh, that's very interesting. So we're not like slip and fall people. So, you know, the lawyers you see on TV that say, you know, you only have to pay if you win. That's not like that. Construction lawyers don't work on contingency. What we do is we pay and we bill by the hour. So we're billed by the hour. So the client that calls us once a day has a much higher bill than the one that emails once a month. So what we do when we engage a client is we talk about the client's budget, where they're at in their business, what they think they want to pay and what they can expect. And we look at expectations. Some clients come with expectations of, let's say they want to learn more about how to better document on the job. They also want to make sure that their contracts are reviewed so that they've got a good purchase order to hand out. Sometimes contractors have been given a contract by an owner or a general contractor and want us to review it. Before we undertake any work, though, we will ask them, how much do you want us to spend? How much time do you want us to spend on this project? If it's an abbreviated period, we may only spend 45 minutes to an hour on a contract. In that case, that would run about $350 to review that contract. A typical contract review, if you're looking soup to nuts at a very detailed contract, could be between $1,500 and $2,000, or it could be more or less depending. But again, we don't pull the trigger on work without talking or discussing what's occurring. A lot of our role too is if things are going bad on a project and you need to document, but you don't have time to do it and you don't know how to do it, oftentimes the construction lawyer will document in the background. So you might call me up and say, look, I've got this issue. People are making claims and sending notices, but I don't know how to do it, or I'm not clear on it. Or can you look over this draft? And we'll draft an email that looks as if it's from you, but it's really from the construction lawyer drafting that email to protect your rights as well. So all of that are things that we can do. But again, we're not in the market and we don't get referrals when you're surprised by things. We want everybody to be on the same page about what the business relationship is and what's occurring. And we've worked on, my partner, Ms. Underwood, negotiated the Inquirer fit out building. I've worked on Citizens Citizens Park when it was being constructed. And we've worked on very, very small projects as well. So projects of all sizes, we want to make sure that the work and the money spent relates in a very logical way to, what is expected. Anything else? By the way, thank you for the kind words. Again, so sorry that I am not able to meet you in person. I look forward to a private Zoom call if you call for general information, or hopefully if we're all safe and can safely meet up in the future, a cup of coffee. I long for the day when we can meet over a cup of coffee.
I want to just reiterate, as companies are preparing their budgets, so we're in March now, we'll be finishing the first quarter of the year. So companies should have their budgets for the year in place, but it is not too late for you to start adding into that budget the cost for professional services, which would be the specific type of attorney that you would need in your business. As Jennifer said, if you receive a subcontract, or if you receive your prime, whether you're a contractor or a consultant, and you receive that document, All you have to do is let that owner or that prime know that you will give the contract or subcontract to your attorney for review, and then you'll get back to them. And that puts you, as Jennifer said, it puts you in a very different light with the owner and the prime, knowing that you are using professional support to protect your interests in in an engagement. So we really encourage you to let them know that your professionals have to review the document because they know their professional has prepared the document. Questions. We want to make sure that any questions that you have of Jennifer, we appreciate the time that she gives us each year. And her time with us during this webinar is free. But she, as soon as we click off this webinar, you're going to give her a call and she's going to provide you with whatever that rate is as she discussed. So we appreciate what she has done in giving us time. We want to make sure that you ask those questions, that you get clarity while she is here. Please use the raise hand function and we will unmute you so you can ask your question or provide a comment before we leave. As we are waiting for you to formulate your question or your comment, we do want to remind you that today's presentation will be available on the PIDC website for your leisure when you want to go back over some of the information. Jennifer gave us a lot of information today. So this presentation, both the video and the audio, will be available on our PIDC blog. We also want to remind you of the webinars that we will have today and tomorrow, partnering with the Small Business Administration as we talk again about the Triple P program. Although we are looking at airport vendors and concessionaires, it is open to any business. So we want to make sure you get those questions asked of the SBA professionals and answered by the SBA professionals. Then on Thursday of this week, we are partnering with the SBA again in providing an information session on the Emerging Leaders program. So a lot of the information that you will get in the business education programs includes information like we're talking about today, when you should hire the professionals to be a part of your team to help you. That's all a part of business growth. I see that we have on the call today, Brian Smith. Brian, can we unmute you and just ask you to give us some information? Brian is a part of the faculty at the community college who offers the Goldman Sachs Small Business, the 10,000 Small Businesses program. Brian, can we ask you to just say a few words? Did we lose Brian?
I think Brian may be muted. He needs to be specially unmuted in order to speak.
Okay.
I don't know.
Yeah, I think we lost Brian really quickly. As I move from Brian, I'm going to ask my colleague Lawrence McComey, who deals with a lot of contractors. Well, let me put it like this. He deals with a lot of projects that are construction projects just based on PIDC financing. So can we unmute Lawrence to see if there are any comments or questions that he may have, if Lawrence is still on the call?
Yep, I'm still here. Good
Okay.
morning, everyone.
Good morning.
I found it very interesting this morning. I actually learned a lot. It was my question about the searches and everything. We have seen where subs get in trouble negotiating contracts with general contractors. And in many times, it's we've been advocating for payments made on a timely manner to subcontractors. So we hope that they learn something about how to document their needs in these contracts going forward. I thought it was very informative this morning. One question I did have, though, is that we're noticing potential for sophisticated wire frauds, meaning that con artists are intercepting information as far as transfers. So we're actually looking into, what kind of insurance coverage can we get for wire fraud and things like that. It didn't come up, but if you experienced that lately, could you just tell us how can we work with contractors to avoid that issue?
I am so happy you raised that issue. It is an epidemic in all business, including construction. It's not widely known, I guess, but the Philadelphia court system, Baltimore City are just two examples of institutions that were paralyzed by cyber attacks. Law firms have been attacked. We are seeing the way we see it come up in construction is someone will say, I have a purchase order, I'd like to make a payment. They will try to transfer the money or encourage someone to transfer the money to a fraudulent account. And that has happened on several times. So, I mean, it's important to look at the actual email address that it's coming through, because a lot of times the email address, instead of coming from jhorn@hornwilliamson.com, it would be jhorn@internet.ru, and it would be an overseas internet. So part of the email address for these contractors looks like it's legitimate. And it used to be that they were not as sophisticated, but these folks will impersonate people on the job and engage in chatter. If anyone is asking for money to be transferred, definitely confirm through the phone and confirm the accounts by setting up confirmation ahead of time.
Thank you.
Sure, but it is a massive, major problem as all for everyone. Any other raised hands that are waiting?
Yes, we do have a raised hand that is available right now. If Quinn, you can unmute them.
All right.
We're waiting on a raised hand to unmute, and that is, I see by the initials of JM. If you can get ready to ask your question, and if Quinn, great. And it looks like you are unmuted and able to talk, so.
Okay, am I still on the platform here?
You are.
Oh, okay, because I was, and then all of a sudden it muted again. The property was basically closed because Ellen and I closed them down because of some work that they need to be done. The heating system, updating the heating system is like $100,000, and the people didn't, don't want to put that out. But I wanted to make a business arrangement with them where I could use the property. I would pay for, pay that $100,000. But I was wondering, is the right thing, like, pay it, do my program, put a lien on it for that amount, and maybe put in a contract option to buy the property, maybe give me a 5-year option to buy the property if I wanted to buy it. Would that be the right way of going about the situation?
I would have to know more about the situation before advising you on that, and I want to see the documents that relate to it. You'd want to have a contract in place to make sure all of that is spelled out. You don't want to rely on just putting a lien on the property. A lien is a last resort. It's something nobody ever wants to do. So it shouldn't be a business plan or part of the business plan. It's much better to have it spelled out in a contract so that way it can be enforced through breach of contract, which is a 4-year statute of limitation and much easier to enforce than a lien.
Great. Do we have any other questions? It is 10:14. I don't want to keep our guest and our guests on unnecessarily. So we want to make sure that we have covered all of the questions. Again, we're gonna wrap this up. We do want to remind you of the upcoming webinars that we have on Tuesday, March 16th. We will conclude our 6-part series, Is It Just Me? The mental health series, and we're going to end with Finding Joy in Difficult Times with Dr. Robin Smith, a renowned psychologist who will wrap up that 6-month series. Brian Smith from the community college had to go to another call, but we do want to remind you that on March 9th and March 25th, we will have information sessions and encourage you to participate so you can learn more about Power Up Your Business, business education, as well as this Thursday partnering with the SBA for an information session on the Emerging Leaders Program. Please stay in touch with us. Go to our website where you can sign up for the newsletter and learn about everything and all the activities that are upcoming with PIDC. And again, if you missed any one of our webinars and you want to get a replay, go to our PIDC blog and you will get the video and the audio. On today, we will only have the video available, only the video presentation today. It will take us a few days before we get the audio. So if you want it today, we can send you just the video presentation, or you can wait a few days and go to our blog and you'll get the full webinar, video and audio. So with that, it is 10:16. Jasmine and Quinn, have we overlooked anything before we end?
No, you've got it all, Marla. Thank you so much to everyone for attending.
Great.
Thank you
And
very
Quinn,
much.
Quinn, did we forget anything before we end? I don't hear anything from Quinn. I guess that means everything is well. Jennifer, please send our regards to Carter. We're sorry that we missed him on today, but for you, best of luck in the Northeast, in Vermont. Be safe, and thank you again for kindly and graciously participating in this webinar.
Thank
I
you
think
very
with
much,
that,
Marla.
thank you. Everyone, stay well, and we look forward to seeing you either this afternoon or tomorrow or Thursday or Tuesday the 16th. But in any event, we look forward to seeing you soon. Take good care. Have a great day.